are day by day becoming more intolerant, selfish as a nation, if I may say so, Mr. Deputy Speaker. Selfish as a world, forgetting that the whole world was populated through migration. Mr. Deputy Speaker, since the beginning of time, people have been on the move. Migration is a fundamental and enduring part of our story as human beings. It has expanded our horizons and opportunities, and it has united us as a global family. We citizens of this country, all members of this House, Mr. Deputy Speaker, we are the descendants of immigrants. I will not go into the history of our country and how it was populated, but it suffices to say that Mauritius is a land of immigrants, Mr. Deputy Speaker. Our ancestors came as settlers, as colonizers, as slaves, as indentured laborers, as traders. And Mr. Deputy Speaker, it is my humble view that as a country, as a nation, it would have been in the spirit of fairness and the right to information that this bill, instead of being brought with a certificate of urgency before this August Assembly, same ought to have been disseminated further, first and foremost amongst the population. We should ask our people as to their views concerning this bill. We should have informed them as to the implications of this bill when it will be enacted. We should also provide our people with a roadmap as to our future immigration policy in the years to come. Yet, this is not the case with this bill, Mr. Deputy Speaker. The civil society has not been afforded with the opportunity to have working sessions, brainstorming on this bill. And this is something that is not in order on such an important piece of legislation. In his intervention, the Honorable Prime Minister has not provided us with much details as to statistics that will back up the necessity and relevance of all new provisions and clauses being introduced in this bill. We ought to know, for example, what is the situation with regard to illegal immigrants, prohibited immigrants, and also the number of marriages of convenience that we have witnessed so far to enable this House and the population to weigh the gravity, if any, of the situation with regard to marriage of convenience. Mr. Deputy Speaker, the Honourable Prime Minister has laid much emphasis on the fact that this bill will tackle this allegedly burning issue of marriage of convenience. Let me, Mr. Deputy Speaker, with your permission, go on this subject matter with regard to marriage of convenience, which I humbly feel has motivated the very basics of bringing this bill before this House. According to media reports, and as per my information, Mr. Deputy Speaker, marriages of convenience, or what we call sham marriages, we've got some 15 to 20 cases involving African and European nationals that are being investigated. They involve foreign workers who have overstayed their work permit and fake students who have entered Mauritius on student visas and whose visas have now expired. But what is a marriage of convenience, and how do we define it for legal purposes, Mr. Deputy Speaker? True it is that our law, as it is, does not specifically deal with sham marriages, but instead lays down the conditions for a non-citizen to marry a citizen of Mauritius in the relevant provisions of the Civil Status Act. It is required, amongst others, Mr. Deputy Speaker, that strict compliance with these conditions, since a non-citizen automatically acquires the status of a resident of Mauritius by virtue of being a spouse of a Mauritian citizen, the Civil Status Act accordingly provides for the publication of a proposed civil marriage by a non-citizen. Once published, any person who has any ground to object to the celebration may in turn lodge a notice of objection of the proposed marriage with the Registrar of Civil Status. It is at this stage that the authorities can intervene to prevent a marriage of convenience. And if the genuineness of the proposed marriage is suspected, the Home Affairs Division of the Prime Minister's Office will lodge a notice of objection to the proposed marriage with the Registrar of Civil Status. Mr. Deputy Speaker, for the sake of clarity, I shall cite the case of Vikram Singh against the Registrar of Civil Status and others. It's a 2017 Supreme Court judgment case. As an example, Mr. Deputy Speaker, the applicant in this case, Mr. Vikram Singh, a non-citizen, had made a publication of his proposed marriage to a citizen of Mauritius in August 2016. The Home Affairs Division of the Prime Minister's Office suspected the genuineness of the marriage, had raised an objection to the effect that, as a non-citizen, he was trying by all means to marry a Mauritian citizen for the sole purpose to acquire automatically the status of resident. The judge in chambers upheld the decision of the registrar, taking into account the fairness of the hearing before the registrar. The judge ruled implicitly, Mr. Deputy Speaker, that the sole purpose of the marriage was one of convenience to enable the appellant to acquire the status of resident. And that meaning of sole purpose, Mr. Deputy Speaker, was canvassed in the UK Supreme Court case of Sadowska that was cited by Honourable Navarre-Marie earlier. In that case, Mr. Deputy Speaker, one Miss Sadowska, who had lived and worked in UK lawfully for several years, had intended to marry one Mr. Malik, a Pakistani citizen who was unlawfully staying in UK since his student visa had expired for some years. In compliance with the law, they published their intention of the proposed marriage. On the day they went to the registrar's office to get married, they were both questioned by the UK immigration authorities and arrested on the grounds that the marriage was one of convenience. In other words, in line with the EU Directive 2004/38 EC, which was applicable to UK as a member state of Europe at that time, the marriage was contracted for the sole purpose of enjoying the right of free movement and residence in UK under the directive that someone would not have otherwise. That was the decision of the Immigration Tribunal. So in the UK, Mr. Deputy Speaker, we have a tribunal for cases with regards to immigration. And this issue of sole purpose should not literally be taken, but rather as meaning that the objective to obtain the right of entry and residence must be predominant purpose of the abusive conduct. So this was the rationale of this particular case. And the second point that they made was a marriage cannot be considered as a marriage of convenience simply because it brings an immigration advantage or indeed any other advantage. And again, as cited by Honourable Navarre-Marie, the onus of proof is on he who asserts must prove. And in this case, it was for the authorities to prove their case. Why I have taken these two cases, Mr. Deputy Speaker, because as it stands, Mr. Deputy Speaker, our legal system is robust enough to deal with marriage of convenience. We've got our Supreme Court, we can refer cases before the judge in chambers, and this new bill will in no case improve or tackle the situation as it stands. Those people who will try to engage in marriage of convenience, if they have this in mind, will just now go on a pause mode for 2 years. Each one of them in the couple living their life and will act after all the legal safeguards are met. So what is of paramount importance, Mr. Deputy Speaker, is our system of justice should be complemented with an efficient civil status office and a proactive immigration office. Those two institutions should be properly staffed and be provided with all the necessary facilities to operate. And as from a legal perspective, Mr. Deputy Speaker, it should not escape the vigilance of our authorities that a marriage of convenience is arguably a conspiracy, contrary to Section 109 of the Criminal Code Supplementary Act, as it entails an agreement between two persons to commit a wrongful act which is against public order, whilst the non-citizen is likely to face a deportation. His or her local accomplice may well have to answer to a charge of conspiracy before our court. So, Mr. Deputy Speaker, our existing laws are available and efficient enough to deal with marriage of convenience. Mr. Deputy Speaker, another issue that is of concern to me in this bill is what most of our honourable friends from this side of the House has been saying. It concerns amendment being brought to Section 11 of the Mauritius Citizenship Act. Honourable members from this side of the House have lengthily canvassed this proposed amendment. Honourable Utim raised pertinent issues with regard to this amendment going against the principle of preventing a non-citizen from being stateless in breach of international conventions. The introduction of a new subsection 8, Mr. Deputy Speaker, that will give the Honourable Prime Minister absolute discretion and without giving any reason deprive any person of his citizenship of Mauritius if he has reliable information and is satisfied that it is in the interest of defense, public safety, or public order. It goes against the spirit of accountability, Mr. Deputy Speakers. The more so that it stands that the existing provisions embedded in Section 11 of this Act already provide the Honourable Prime Minister with wide powers. What is lacking in this amendment, Mr. Deputy Speaker, is a check and balance mechanism. At a time when we are advocating for a more concerted approach on issues of national security, amongst others, I am of the view that honourable members of this august assembly should be empowered, and there should be a creation of a Home Affairs Committee, as is the case in the UK, for instance. This committee should be a cross-party committee of MPs responsible for scrutinising the work of the Home Affairs Division of the PMO and its associated departments. It should, amongst others, examine government policy, spending, and the laws in areas including immigration, national security, and policing. And as a note of conclusion, Mr. Deputy Speaker, I will invite members of this august assembly to take note of the recent revelation made in a documentary on the BBC with regard to Sir Mo Farah. Honourable members will recall that he is one of Britain's greatest ever athletes, having won as much as 4 Olympic gold medals for Great Britain. In recognition to his outstanding contribution to the field of sports and athletics, he was knighted and was bestowed upon with the prestigious title of Sir. He is now called Sir Mo Farah. Astonishingly, Mr. Deputy Speaker, he recently revealed that the truth is that his name isn't even Mo Farah. He revealed that he was born as Hussein Abdi Kahin in Somaliland, and that he is an illegal immigrant smuggled into the UK by traffickers when he was 9 years old. He was brought here under a false identity to work as a servant in the United Kingdom. And he says, and I quote, "Now at the age of 39, I must say the truth. The truth is I'm not what you think I am. And now, whatever the cost, I need to tell my real story." And he went on and relate how he became an illegal immigrant and how he struggled to become where he is now. Fortunately there, Mr. Deputy Speaker, the Home Office has adopted a fair approach and no actions whatsoever has been taken against him, and Sir Mo Farah stays on as a proud British citizen. How many such cases we have around the world, and even in Mauritius, Mr. Deputy Speaker, where people who have stayed in a country as illegal immigrants have later moved on to make the nation where he or she is living proud. Mr. Deputy Speaker, I have a liberal approach to immigration. I am of the view that as a land of immigrants, having no borders, having already existed legal framework to tackle all types of illegal practices, related to immigration, instead of this bill adopting a restrictive approach, there ought to have a proper and widespread debate for the adoption of a national immigration policy for the next 30 years before coming up with an appropriate piece of legislation that will have a broader perspective to immigration. I must also remind this House, Mr. Deputy Speaker, that research on the net fiscal impact of immigration, I've listened to the Honorable Ramdani with regards to impact on our economy. So research on the net fiscal impact of immigration shows that immigrants contribute significantly more in taxes than the benefits and services they receive in return. According to the World Bank, Mr. Deputy Speaker, increasing immigration by a margin equal to 3% of the workforce in developed countries would generate global economic gains of 356 billion USD. 366 billion USD. Some economists, Mr. Deputy Speaker, predict that if borders were completely open and workers were allowed to go where they pleased, of course, in an ideal world, we are not in an ideal world, it would produce gains as high as $39 trillion for the world economy over 25 years. Mr. Deputy Speaker, sir, I thus invite honourable members to have an open-mind approach to immigration, as we are all immigrants on this planet Earth. I thank you for your attention, Mr. Deputy Speaker.
Thank you, Mr. Deputy Speaker, sir. It is indeed an honor for me to take a call and to support this immigration bill. Mr. Speaker, sir, much has been said in all quarters: media, radio talk shows, newspapers, the political spectrums, among others. However, Mr. Deputy Speaker, sir, as I lend my voice to this piece of legislation presented by the Honourable Prime Minister to this House, I call upon the good faith of my colleagues from the other side of the House. I have been listening to the former member, Honourable Lobin, who mentioned about liberal approach, open-minded approach, but on the same side of the House, there were some members who have made this debate around one single individual. That's the person, Peter Ulrich, who was actually deported. Allow me here to put few questions to those members of the opposition who took the floor and personalized the debates as they had their clients or clients of their friends involved in illicit activities. Let me refresh the memories of some friends on the other side. During an answer from the Prime Minister on the 10th of May 2022, where the Honourable Rizautim put a question with regard to that said person, the Honourable Prime Minister mentioned in his answer, I quote, "Mr. Speaker, sir, as I said, Mr. PU was wanted in Slovakia for establishing, masterminding and supporting a criminal group, and also for the illicit manufacture, possession and trafficking in narcotics and psychotropic substances, poisons or precursors. I have also informed the House about the outcome of the case." So my question to members on the other side of the House who have tried to personalize the debate, trying to make the public at large feel that this bill has been brought specially to protect that person, to bringing this bill to work towards that person, I think they are getting it wrong. Because this person who was here in Mauritius wanted to have the Mauritian nationality. So I think this is an example why we should come forward with this immigration bill. Mr. Deputy Speaker, sir, I shall not be too long, but my speech would dwell upon the main object of the bill, which clearly dissipates any doubt, if so ever. The very main object of this bill is to consolidate and strengthen the law with regard to the admission and stay of non-citizens in Mauritius. Et non pas, si pas get figure, you go away. This is what has been said in this August Assembly. Well, it speaks a lot about what type of policymakers they shall be, but thank God they are on the other side of the house. Sinon, beaucoup figure pas pour passer. Anyways, coming to the essence of the bill, Mr. Speaker, sir, as I mentioned, we are talking about strengthening and consolidating an immigration act which exists since 1970s, where some of us were not even born. And this act, which dates far back, made provision for a limited category of non-citizens to be admitted and stay in Mauritius. And since then, as mentioned by my colleagues, the act has been amended several times to make place for retired citizens, investors, and non-citizens, as well as young professionals. Immigration on a worldwide basis has become an ever-increasing problem. Immigration is a cornerstone of any government's long-term goal in respect of economic transformation, our focus on families, young, old, and our national identity revolves around immigration. The new global environment has increased competition for skilled migrants, and there is a greater need to ensure that Mauritius is secure. With such facilities comes some serious issues which this bill comes to address. This bill does a number of things which I will highlight with some key issues in it. Mr. Speaker, sir, the very first issue is the marriage of convenience, which has become an alarming phenomenon not only in Mauritius but across the globe. People getting married for their own benefits and to get the papers and to be naturalized. As a responsible government, we had the urgency to address this issue. The legislation brought in this House clearly makes new provisions to avoid situations such as, 1, a non-citizen marries a citizen only for the sake of obtaining a resident permit to stay in the Paradise Island of Mauritius. Secondly, the marriage between the non-citizen and the citizen should be a civil marriage, and the non-citizen will have obtained a temporary residence permit to stay in Mauritius. Thirdly, following the 2 years, the non-citizen will be eligible for a residence permit. Furthermore, this bill also clearly provides support to non-citizens who, for any reason, medical, business, or any other reasonable purpose, had to travel abroad, but for 1 year has been under the same conjugal roof in Mauritius. Another element which is believed to be very important, which we need to lay emphasis in this new legislation, would empower the immigration officer. We have been discussing about the power given to the Prime Minister, but I couldn't hear members of the opposition mentioning about the power, about empowering the immigration officer, who will have the ability to investigate into the problem of marriage of convenience. Part 5 of the bill states clearly powers of the immigration officer. Section 21, non-citizen minors admitted to Mauritius. Section 22, examination by the immigration. Section 23, powers to refuse admission to Mauritius. Section 24, inspections. Section 25, powers of arrest, detention, and investigation. All lies upon the immigration officer. Mr. Speaker, sir, the aim of this bill is to modernize and future-proof our immigration legislation, which dates far back to the 1970s. As a responsible government, it is vital that we have legislation to allow us to protect the security of our citizens. This bill clearly brings a fair and balanced way of managing the immigration issues, which is a global issue. To conclude, Mr. Speaker, sir, I do not want to unduly delay the passage into law of this very important piece of legislation, but I add my congratulations to those who have been involved into drafting such an important bill, and especially to the Prime Minister for bringing such an important bill into the House. In view to safeguard the interests and well-being of our citizens, protecting them from being exploited, it is therefore important to consolidate and strengthen our immigration bill with such a robust bill. I therefore extend my full support to the Prime Minister and to this bill. Thank you very much for your attention.
Thank you very much. Short and precise. Honorable Fadumia, Dr. Mia.
Thank you, Mr. Deputy Speaker. My intervention this afternoon on the immigration bill will not be a long one, save and except that I wish to highlight certain contentious and somewhat alarming provisions which have come across when going through the bill. Mr. Deputy Speaker, sir, the bill has two major components. Firstly, the issue of marriage of convenience to obtain a residence permit, as well as the marriages between a citizen and a non-citizen, and its subsequent application for a resident permit. And secondly, the very consequential amendments to the Deportation Act, the EDB Act, the Mauritius Citizenship Act, and the Passport Act. Mr. Deputy Speaker, sir, there is no doubt that our legislation needs to be tighter, and it comes to the so-called couple having resort to marriage of convenience, and surely such practices, which have been used by so many in different countries across the globe, have compelled immigration authorities across the globe to make new provisions to deter and prevent such scams where the sole aim, and I repeat, the sole aim, is to circumvent the rule of entry, obtain a permit of residence, and abuse the welfare state of the country. Mr. Deputy Speaker, sir, however, one has to be cautious, though, where there are many perfectly genuine marriages which may bring some immigration advantage to one or both parties involved, depending on where at the material time they wish to make their home of residence, and that obviously does not make it a scam marriages. Mr. Deputy Speaker, sir, people marry for a variety of reasons, and many genuine couples who might not otherwise marry do so in order to be able to stay with their loved ones in the country. It is therefore extremely important to define whether the sole purpose is to gain an immigration advantage or whether the sole aim is to circumvent the rules of entry of residence. The issue is between what was the intention. Was it a sole purpose or a sole aim? And I hope that amendment to the law will clarify this issue as to the detection of genuine, what we would call, marriage of convenience. Mr. Deputy Speaker, sir, let me come straight to the other point. The immigration bill is not only brought to bring certain amendments to the existing legislation. The bill also seeks to revamp the whole landscape in terms of citizenship and the regulation of all permits, which are normally issued by the executive and the so-called independent authorities, and which may have dire consequences. Mr. Deputy Speaker, sir, one of the components of this bill, which has attracted a lot of discussion, either from this side of the House and members extra-parliamentary, from learned counsel and lawyers, is that Section 39(4) and Subsection F, where the new subsection will be added to the Mauritius Citizenship Act, where I note the following: absolute discretion and without giving any reason, deprive any person of his citizenship of Mauritius if the Prime Minister or the Minister of Internal Affairs has reliable information and is satisfied that it is in the interest of defense, public safety, or public order. Mr. Deputy Speaker, sir, as much as certain provisions are needed clearly, one must bear in mind that the new bill ought to be in line with the basic tenets of good governance. The decision of a person's citizenship should not rest within the sole discretion of the master of the day, and whoever be the master of the day, today, tomorrow, or in the years to come. Mr. Deputy Speaker, sir, if we now go to the Mauritius Citizenship Act of 1968, which the bill seeks to amend, and I have just read out, one would be aware and note the various safeguards which have been put in place prior to such a drastic decision being taken, the most so to be taken by one individual. Mr. Deputy Speaker, sir, for example, it used to be the case that before an order to deprive any person of its citizenship is taken, there is a statutory requirement that that person is afforded A, right to an inquiry, B, a notice to be served on him, and C, if the inquiry and a report to a committee appointed by him for that purpose. Those were surely shooty measures to ensure that a fair and non-abusive decision were taken, but not solely based on personal views and opinion. Mr. Deputy Speaker, sir, what does that all mean now? It means simply that such a decision to deprive a person of its citizenship should not be left solely at the discretion of one person, in the present case, the Minister of Home Affairs. There used to be various safeguards, of which I have just mentioned, such that an order to deprive a person of his or her citizenship is not used in an abusive manner. Mr. Deputy Speaker, sir, I will just relate as an example a very telling case that happened in the United Kingdom only 5 years ago, when a young girl at the age of 15, named, it's well known, Shamima Begum, decided to leave the United Kingdom. She is a citizen, born and bred, and decided to flee to Syria to join an infamous organization, ISIS, for reasons unknown to many, but decided that that were her dream. She wanted to live her life. Unfortunately, the whole dream fell apart, and she decided to come back to the United Kingdom in 2017 with an unborn child at the time. Mr. Deputy Speaker, sir, why I'm relating to that? At that material time, in 2019, the Secretary to Home Affairs, Mr. Sajid David, decided to strip her of her citizenship. And what happened next? She was allowed to pursue her request to come back to England to defend her case. And in July 2019, she even went to the Court of Appeal, where she was given the right to come back to UK and to fight her case of citizenship. However, the judiciary in this particular country also allowed the government of the United Kingdom to contest the ruling of the Court of Appeal. And it went to the Supreme Court, Mr. Deputy Speaker, sir. And in the Supreme Court, the Home Office appealed to the Supreme Court to reconsider the Court of Appeal judgment on the basis of significant national security risk. And the ruling was very simple. The President of the Supreme Court said that the government was entitled to prevent Ms. Begum to return to UK on the basis of national security threat and terrorism. What I'm trying to point out, that there is a clear demarcation between the executive and the judiciary, and whoever felt aggrieved at the time was given opportunities, there were safeguards, there was avenues to contest, and shooting measures to make sure she had a fair trial and a fair decision be implemented against her. Mr. Deputy Speaker, sir, not long ago here in Mauritius, we've seen the mess where one PU, Peter Rusek, was deported in a somewhat surprising manner, and which even necessitated rectification, clarification communique from the Office of the Prime Minister to reassure the population of the acts and doings of the government. But, Mr. Deputy Speaker, only last week, we've seen that the Director of Public Prosecution took the decision to proceed with the criminal contempt trial against the Passport and Immigration Office and the Civil Aviation due to judge orders not being respected. We are not condoning that such infamous individual, as said by Honorable who just spoke before me, Lachman Roy, that this guy was masterminding drug trafficking, was involved in heavy drug businesses and what's on. We were not the one who allowed him a red carpet through the Economic Development Board to come to this country. The check and balances were poor, and one has to accept that remedial approaches have to be taken in this manner. Mr. Deputy Speaker, sir, the fact that a communique had to be issued in that sense gave an indication of the manner in which the so-called deportation had been handled. The other case, Mr. Deputy Speaker, sir, of Patrick Hoffman, whereby he was deported and subsequently reported as a prohibited immigrant because it was believed he has caused great harm to the national aviation air Mauritius and industry, and also making subjective remarks. Let's not forget the Sri Lankan lady who was heavily pregnant of 6 months, and he was deported in circumstances we all know about. These were very subjective decisions. One, Mr. Deputy Speaker, sir, one must take lessons of the President of France, Mr. Hollande, who tried at some point in time to change the constitution to expel terrorists from mainland France. And he met with such opposition and upheaval in the country that he had to backfire and thereby stayed as it is. Mr. Speaker, sir, I will now come to the bill itself, particularly subsection 8(4)(c), where I note that the Minister of Home Affairs may issue a residence permit to a non-citizen where the non-citizen is, in the opinion of the minister, a fit and proper person to become resident. Mr. Deputy Speaker, sir, the granting of a residence permit to a non-citizen is something one must be very cautious. On what criteria would the minister determine that the non-citizen is a fit and proper person? Should that not remind the House of that infamous businessman, where one senior honorable gentleman sitting on the other side of the House, who has even acted as Prime Minister, said that he looked into the eyes of the businessman and was convinced that he was a genuine person. The subsequent trials of that gentleman is a central criminal investigation of court in Portugal only a couple of months ago says it all. I would say to my dear learned friend on the other side who just spoke before me, beaucoup figures parti pour capable passer si nous étions au pouvoir. Truly, that businessman would have never had set foot here. Mr. Deputy Speaker, sir, amendments and new provisions in the bill must not and should not be the means to use one authoritative power against individual citizens who oppose and challenge the government in place, and acting upon one's discretion under the covert of national security risks or threat to strip them of their citizenship, but particularly if it happens to the offspring of foreign national. The constitutional rights of children born out of couple binational, that is one parent being a foreign national, and the obtention of a Mauritian nationality must be guaranteed. Mr. Deputy Speaker, sir, lastly, I would like to comment on Section 12 of the bill, which relates to the occupation and permits. I have not seen any provisions which give the power to the relevant authorities to carry out any checks or inquiries in relation to an applicant for an occupation permit. I again have to refer to the case of Mr. Urisek, where an occupation permit of 3 years was granted to him after allegedly verifications were carried out on the controversial list of Passport and Immigration Office, the Interpol database, and well checked. And to find out there was only an international arrest against him in May 2020. And again, he's been a notorious drug trafficker, and only 3 years later, we realized this guy had to be deported. There is a way of doing it, because the way the Mauritian authorities have acted smacks clear amateurism. Mr. Deputy Speaker, sir, this sort of shortcoming and amateurism should not repeat itself, as it put at risk population at large and forget the reputation of our country. It is therefore, in my humble view, that this new bill must contain provision to the effect and empower officers of the Director General of Immigration to be able to verify all the elements of applicants who wish to obtain and benefit an occupation permit. The alleged occupation with the intent to undertake must be thoroughly verified, and the bill must be amended to include those powers. Finally, Mr. Deputy Speaker, sir, I note with satisfaction that the period of notice for marriages between non-citizen and citizens has been extended from 10 days to 30 days, which I hope is made in the view to allow the more thorough checks and inquiries to be carried out on non-citizens to ensure that the marriage is not simply a routine to obtain citizenship in Mauritius. I further note that a non-citizen does not de facto will acquire citizenship the moment he or she is married to a Mauritian citizen. This is also a step forward to prevent the mariage blanc, like it is referred in French. To conclude, Mr. Deputy Speaker, sir, I can only hope that my suggestion and positive criticism will be taken on board by the executive, as this is above political partisan. Thank you.
Thank you very much, Honorable Daniel.
Thank you, Mr. Deputy Speaker, sir. Listening to the speaker speaking before me, I don't think he has read why we are making this amendment. If we had in the past this legislation would not have been the case for PU. You understand that when PU entered Mauritius, you said that there was not regular check was done, but you should know also that the Economic Development Board used the World Check and all relevant checks that has been done, he was not condemned at that time. This is important to know because when the government of Mauritius was made aware of the international arrest, the Attorney General Office and the Prime Minister's Office acted promptly. And this is why this gentleman is no longer in this country. And when we are bringing amendment to this act today, when we are talking about this, many things has been said about this citizenship act by Honorable Utim, yourself, the member that speak before me. But why are we doing it? It's important to understand that. It is, if tomorrow we have a terrorist in this country. So we know that in the past, there is the law. You can also go toward the Supreme Court because it's by our Constitution. But now, if the Prime Minister gets an information on a terrorist, he will write to him, tell him, you know, I'm going, you know, to prohibit you from being in this country because I suspect you to be a terrorist, and he will go in the court. By that time, Mauritius will be explosé. We need to act properly, but the law is still here. Even if he's repealed from his citizenship, he can still use the Supreme Court. This is not that the opposition has been telling, and this reminds me of how there was the same, you know, in 2019, reading in Hansard. There was the same, when the opposition was saying the same tactics and using the same thing that we are giving too much powers to the Prime Minister. Et c'est un point qui a suscité beaucoup de débats, c'est la discrétion conférée au Premier ministre. And here I would like to quote Honorable Ivan Kolandavelu from the Hansard in 2019, during the same Immigration Act. Je suis tenté de dire, si un Premier ministre, on ne vous donne pas une discrétion, mais à qui on va donner de discrétion? Le Premier ministre reçoit une information et il lit cette information et se dit que cette personne raisonnablement sera indésirable. Cela a mené à des excès de commentaires tels qu'à partir maintenant, on devrait adresser à l'honorable Pravin Jagnat comme Sa Majesté, puisque à partir maintenant, il faudra avoir sa permission avant de se marier à un ou une étranger, une étrangère. Où est-ce qu'on va chercher dans ce texte de loi? Il faut savoir un esprit véritablement tordu pour trouver cela. I quote, Mr. Deputy Speaker, sir. We have a Prime Minister which has been democratically elected by the people of the Republic of Mauritius. And here we on the side of this House, we have full confidence in his judgment, and we know information won't come from Honorable Dunn, who is going to give the Prime Minister information about a foreigner or someone who is coming here. It's about intelligence. We're not talking about what are we talking. We're talking about intelligence, Mr. Deputy Speaker, sir. And we have intelligence between our partner countries. This is how we are going to proceed, Mr. Deputy Speaker, sir. And, Monsieur le Président, Maurice est classé parmi les 21 pays considérés comme fully democracy par l'économiste et intelligence unite de le rapport 2021, parmi les 21 pays. Nous sommes le seul pays en Afrique parmi les 21 qui sont dans ce rapport comme fully démocratie. Parce que vous allez voir qu'est-ce qu'ils ont quand l'opposition faire leur marche, ils sont autorisés, mais ils vont dire que nous sommes dans la dictature. C'est tout le temps comme ça. Depuis que nous sommes là, on a entendu ça. Le Premier ministre est un dictateur, le gouvernement est dictateur, et nous empêchons, et nous sommes en train de donner trop de pouvoir au Premier ministre maintenant dans ce texte de loi pour qu'il puisse revoir les citizenship. Mais moi, je vais aussi, parce que l'honorable Lobin a parlé, et il a demandé des statistiques. Moi aussi, je voudrais des statistiques du Premier ministre depuis le Immigration Act de 2019. Combien de prohibited immigrants there has been? On a parlé, on a dit que il y avait l'honorable Tim qui était inquiet par rapport à les deux côtés de la Chambre qui sont mariés à des étrangers. Mais si on a dit aussi qu'il pourra demain, le Premier ministre, servir de cette loi pour faire vengeance politique. Mais combien de gens de l'honorable banque qui sont mariés avec des étrangers ici ont été prohibited immigrants? Moi, je voudrais savoir ça du Premier ministre. Mais non, nous sommes en train de les accueillir parce que, comme nous avons dit et comme nous le savons nous ici, oui, we are in a land of immigrants. I agree. Parce que Maurice a été créé, nous avons des gens qui sont venus de toutes les parts du monde. Et aujourd'hui, on vient nous dire que le Premier ministre va servir de ce pouvoir pour faire du tort à des épouses des membres de l'opposition. Je ne sais pas où on va chercher ces arguments-là. Parce qu'ici, qu'est-ce qu'on fait? Nous sommes en train de les encourager d'investir et de faire du business aussi. Si vous allez voir, nous n'avons pas bloqué personne, Monsieur le Président de la Chambre. Venant, coming to the Act, like everyone has said, in 1970, the Act was complex, but simplified legislation was required. And this enactment of this new bill is warmly welcome since the present Immigration Act dates back to 1970 and has been amended 20 times. The result is that we have a legislation which was complex and difficult to understand. The new piece of legislation is easy to read, making it a good marketing tool for investors and is in line with the spirit of openness. Comme on le dit, il fallait revoir la politique nationale de l'immigration. Parce que dans les années 2000, Maurice s'ouvre au monde, il y a la migration circulaire. Les Mauriciens vont vivre ailleurs et les étrangers sont en train d'inviter et venir travailler à l'île Maurice. Et nous avons vu aussi que c'est une question de pouvoir balancer. D'abord, la nécessité de protéger la liberté du mouvement, les droits fondamentaux de la famille, le droit de la famille d'être toujours réunis, mais aussi le droit de l'État de se protéger contre des personnes les prohibited immigrants qualifiés dans ce texte de loi par rapport à les activités qu'ils sont en train de faire. Parce que nous devons protéger nos citoyens et aussi notre petite île Maurice. Petit État insulaire, Small Island Development State. Il faut le faire, Monsieur le Président. Mais aussi, quand on parle de prohibit the marriage of convenience, the main aim of the new piece of legislation is to prohibit marriage of convenience, les mariages orchestrés, for the sole purpose of obtaining residence permit. To this end, the law is being strengthened so that a non-citizen is not outright be eligible for a residence permit. The concept of a temporary residence permit is being introduced. Thus, a non-citizen spouse who is civilly married will obtain a permit allowing the spouse to stay for a period of 2 years. It is only after this period of 2 years that the spouse will be entitled to apply for a residence permit, which is good. But when listening to Honorable Lobin also, when we look at the European Convention on Human Rights and also which reflects in the International Government on Human Rights, So when you see the number of applications that has been made religiously to the European Court of Human Rights under Article 8, many cases for spouse visa are refused on the ground of national security and the ground of public morality. And Mr. Deputy Speaker, sir, the law had to be amended in England and Wales so as to ensure that number of immigration regulations were amended so as to secure their border. And that's why even structure of the Foreign Office and the Home Office that had to implement introduced another special branch in UK Border Agency. Now it is not the Home Office that deals with it, it is a UK Border Agency. Mais, Monsieur le Président, il y a aussi, on a pris l'exemple de l'Angleterre, mais en Angleterre aussi, on peut repeal le citizenship. En France aussi, on le fait. Mais pourquoi pas l'île Maurice? Si nous avons des oiseaux, des immigrants qui ont fait des actes, qui ne sont pas, comme on dit, des terroristes, des gens qui sont illicites, des drug dealers, drug traffickers, on doit protéger notre pays. C'est pour cela que cet amendement, nous l'apportons au Parlement aujourd'hui. Mais pour venir aussi, je voulais aussi répondre à l'honorable Boulel. L'honorable Boulel avait dit, Monsieur le Président, dans son intervention, Mr. Deputy Speaker, let me quote l'honorable Boulel, Mr. Deputy Speaker, sir, the MSM regime is very cruel, and I can refer to the battalion of cases to show its impervious or insensitive to human rights issues. The case of a Belgian pilot married to a Mauritian citizen is a classic case of what it means to be a victim of unfettered powers conferred upon the Minister or Prime Minister. And on 16 April 2019, amendment to the Immigration Act of 1970 was passed to make the pilot, I think many use this example, Mr. P. Hoffman, a prohibited immigrant in virtue of Section 8(1)(m). There was also the case of the Sri Lankan lady who was more than 7 months pregnant. Ring a bell, she was jumped on a flight to Sri Lanka and decision was taken despite a favorable ruling given by the Supreme Court to stay action, that is the MSM culture, devoid of human feelings and indifferent to the rule of law. The MSM bend the rule to serve its purpose. Money talks indeed. Unquote. Monsieur le Vice-président, si nous avons quelqu'un qui nous avons donné un residence permit, il entraîne de faire des désordres et à Mauritius et nous coûte à l'État et à la compagnie nationale, qui aujourd'hui nous savons dans quel état est le paillant queue. Mais je vois, pourquoi pas le Premier ministre n'agit pas? Il doit agir, parce qu'on doit protéger notre pays et aussi nos compagnies nationales. Mais venons au Sri Lanka, au case de Sri Lanka, je suis allé voir par rapport du cas que l'honorable Boulel avait mentionné. Il avait mentionné le cas de M. Djogui. Hein? Il avait mentionné ça. Laissez-moi, Monsieur le Président. Il a visité Djogui et c'est le cas de Djogui et Meda Gama. Je ne suis pas un homme de loi ou comme l'honorable Tim, l'honorable Bin ou même l'autre, mais je vais citer ce que j'ai lu dans le jugement. Djogui vient précisément établir ce que tout le monde vient dire. Je ne vais pas relire tout ce qu'il y a dans le... Monsieur Djogui avait entraîné une application. Sa femme était une Sri Lankaise, enceinte de 8 mois, menacée de déportation. Ils vont devant le juge et demandent de suspendre l'autre. Le juge, contrairement à ce que l'honorable m'a dit, n'avait jamais donné une injonction. Il avait refusé l'injonction. Le jugement est devant moi. Il avait demandé à l'État de venir s'expliquer. L'État, se prévalant de cette petite faille, avait pris Mme Djogui, l'avait mise sur le premier avion et l'avait renvoyée quelque part. Le juge Annie, se prévalant de ce que le Home Secretary avait fait à subir dans une affaire quelque temps auparavant, dans l'affaire de M contre le Home Secretary, avait à cette époque été trouvé coupable d'outrage et se prévalant de ça, se dit, I quote Mr. Deputy Speaker, je demande au DPP d'examiner si dans le cas du Premier ministre d'alors, Feu Sanirou Jagnat, nommé dans le jugement, le gouvernement, le commissaire de police, et n'avait pas été coupable d'outrage à la cour. Unquote. Mais ce que l'honorable Boulel ne nous dit pas, ce que personne ne dit, ce qui paraît dans le jugement aussi, c'est que M. Djogui, celui qui avait fait l'affidavit et avait présenté la demande en cours, n'était pas M. Djogui, le mari de Mme Medagama. C'était un faux. C'était l'amant de cette dame-là. Et Feu Sir Gaëtan Duval, qui avait été son avocat, n'était pas à Maurice quand tout cela est arrivé. Quand il débarque, Maurice, il s'apprend tout cela, il va voir le juge Annie, qui lui se retire de cette affaire-là et ne veut pas avoir à défausser. Il se retire de l'affaire et le juge nomme Awaldo d'office ainsi que d'autres avoués pour paraître d'office pour ce M. Djogui. La police capte M. Djogui, bien sûr, et va chercher le véritable M. Djogui. Le véritable M. Djogui dit, oui, j'avais épousé cette femme parce que j'étais fou amoureux d'elle et qu'elle faisait semblant d'être amoureuse de moi uniquement pour avoir la nationalité, mais au fait, elle avait un autre amant qu'elle vivait et qu'elle entendait un enfant. C'est la vérité, et quand véritable Djogui vient devant le juge et dit, monsieur le juge, je suis le premier à demander la déportation de cette dame, ma femme. Et c'est comme ça, le juge Annie ne démissionne pas parce que la dame a été déportée. Il démissionne parce que le DPP et lui tombe en désaccord avec le chef juge et le DPP d'alors. Je vous dis ça, et c'est pour cela qu'il avait pris sa retraite, non pas pour ces choses burlesques que nous avons entendues, mais il faut dire la vérité, l'honorable Boulel. Comment c'était dans le jugement, pas en partie. On doit tout dire. Et, Monsieur le Président, je voulais aussi venir par rapport à, comme on dit, in this bill, the immigration officers are being empowered to investigate whether marriage being a non-citizen and a citizen is a marriage of convenience. The Civil Status Act is also being amended to provide that a marriage between a non-citizen and a citizen will now be celebrated in Mauritius after 30 days of the publication of the marriage, instead of 10 days. This is being done to give to the relevant authorities adequate time so that they may conduct appropriate checks. These measures will ensure that there are no marriage of convenience and that Mauritius grants residency only to deserving people who meet criteria to set out in the law. It is important for us to preserve the good repute of Mauritius. With regards to young professionals, we have talked a lot, and it is recognized in the businesses lack the required labor force to enable them to prosper and grow. We have a skill mismatch. This is true, Mr. Deputy Speaker, sir. For this reason, we welcome the fact that the field of activity under which young professionals may apply for a young professional permit, which will enable them to work and reside in Mauritius, is being increased to include fields such as architecture and design, communication and media, creative industry, engineering, logistics and supply chain, travel and tourism. This is an important measure to support our businesses. The importance of good repute of Mauritius, I have stated it earlier, Mr. Speaker, sir. Mr. Deputy Speaker, sir, that we are reviewing the sentences to a fine not exceeding 1 million rupees and 12-month term not exceeding 12 months of imprisonment, and for 5 years showing the commitment and determination to send a strong signal that breaches of Immigration Act will not be treated with leniency. We talk about fractional ownership also. The Immigration Act is also being amended so that a residential property acquired by more than one non-citizen will be eligible to apply for status of residency, provided that the investment by each non-citizen exceed 375,000 USD. A non-citizen property restriction act, by the way of consequential amendment, the non-citizen property restriction act is being amended to allow non-citizens who are resident to purchase property outside the existing scheme, as long as the purchase price is not than 350,000 US dollars. Thus, holders of temporary residence permit, permanent residence, occupational short-term occupation, family occupation may be allowed to acquire property other than residential property situated on a pagiometric BLN or service land exceeding 1.5 ARPA, standalone residential property constructed in land exceeding 1.5 ARPA. And to conclude, Mr. Deputy Speaker, sir, I would like to commend the Prime Minister and all the team that has worked on this bill, so that we are here to protect our citizens and protect our country in the best way. And we, on this side of the House, we are in for this bill. Thank you, Mr. Deputy Speaker, sir.
Thank you very much, Honorable Buddha, please.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, sir, we are a land of immigrants. This has been said. We are no longer a land of immigration. I'm thinking of Australia or Canada. But we are a land of migrant workers, where we have tens of thousands of workers with this temporary stay in Mauritius. So we are a land where we allow some immigration according to our national interest, for purposes like investment, retiree residents, self-employed, professionals, young professionals. These categories are clearly set, and we have been opening our economy and our country since 2005, where the scheme of occupation permit was launched. In fact, it combined, for the first time, the resident permit and the work permit in one document. And it introduced the concept of silent agreement, which is still being valid in this law. Mr. Deputy Speaker, sir, in the 1990s, I was the chairperson of the Work Permit Committee when massive import of labor was introduced in the wake of a dynamic and very vibrant textile sector. Before that, a work permit would take more than 6 months. But the idea was to make things faster so that the vibrant textile industry could have the workers which it needed. And today, the occupation permit can be obtained with the silent agreement within 5 days. It is clear, Mr. Deputy Speaker, that the Prime Minister and the Prime Minister's office want to cure certain loopholes and abuses in the legislation of today. But I am convinced that the amendments are too autocratic. Contrary to the UN conventions, contrary to UN charters, contrary to the African charters, my colleagues on this side of the House have mentioned these issues. The amendments, the new bill, raise constitutional issues such as discrimination and the right to a legal remedy against the absolute discretion which the bill gives to the Prime Minister. The first thing I would like to say, Mr. Deputy Speaker, is that in section when it relates to deprivation of status of resident in clause 18, we are given a list where the minister, that is the Prime Minister, is satisfied. When he is satisfied, he can deprive somebody of his status of resident. And in subsection 2, we have this famous sentence which has been criticized all the way, not only in this assembly, but outside as well by eminent lawyers and the public in general, which says, notwithstanding subsection 1, where you have the categories where the Prime Minister can deprive the resident, where the minister is satisfied that it is in the public interest to do so, he may, in his absolute discretion, deprive a non-citizen of his status of residence. I am proposing that we remove the word absolute. And we can keep the word discretion, but we all know that discretion by a prime minister or the prime minister's office or any institution has to be used judiciously and not as a punishment. An unfettered discretion cannot be allowed in a democratic society, Mr. Speaker, sir, Mr. Deputy Speaker. I'm also astounded by the fact that the word minister, that is the Prime Minister, is mentioned 59 times in this bill. And in all cases, you have the criteria. We have the criteria where the law can be applied, and then we have the situation where, notwithstanding those criteria, the Prime Minister can use his discretion. I'm going to take a few examples. But before that, I would like to go back to 1977, where the Human Committee of Human Rights raised the issue of Mauritius, where Mauritian women said that there was a discrimination because their spouse couldn't stay in Mauritius and had to apply for a residence permit. There was a convention then, Mr. Deputy Speaker, which said that the wife has the legal duty and the moral obligation to be with the husband. So if a Mauritian lady was getting married to a non-citizen, she had to accompany the non-citizen to his place to his place of residence. So the Mauritian wife couldn't stay in Mauritius and had to accompany the husband, and the husband couldn't stay in Mauritius because he had to go to his country of abode. And this is what the committee said. The committee found out, Mr. Deputy Speaker, the Committee of the United Nations, that any discrimination on the ground of sex within Mauritian legislation without sufficient justification was tantamount to a violation of Articles 2 and 3 in conjunction with Article 17, as well as direct violations of Article 25 and 23 of the UN Charter. So the committee recommended that Mauritius adjust the provisions of the Immigration Amendment Act 1977 and the Deportation Act, and had to implement its obligations to prevent sex discrimination in its laws and regulations, Mr. Deputy Speaker. Now let me come to the legislation, Mr. Deputy Speaker. We have the introduction of the temporary residence permit, where a spouse of a Mauritian citizen is given a permit for 2 years after getting married. Honorable Navarre raised this issue of how this can affect the future of a marriage or the future of a family, how a spouse of a Mauritian citizen doesn't know whether he or she will be given the opportunity to stay in the country after 2 years and being given the status of a temporary resident when they have to have a family, take loans, build up their future. And if somebody, a non-citizen, gets married to a citizen of Mauritius and they decide to live in Mauritius, what does that mean? It means that that person has decided to make Mauritius the land where he or she wants to have a future. So I'm totally against this temporary residence permit of 2 years, and then have to wait another 2 years to be able to apply for a resident permit, which is going to be later which can become a permanent residence permit. Now, let me go to clause 5, where we can restrict on admission or remaining in Mauritius. Notwithstanding this act, no one shall be admitted to Mauritius whilst being in Mauritius remain where the person suffers from an infectious, a contagious, or a communicable disease. A person who has been convicted, this we can prove this. C, a prostitute or a person who lives on the earnings of a prostitute, or a person who is reasonably suspected to come to Mauritius for an immoral purpose. D, a habitual beggar or a vagrant. E, a person who is likely to become a charge on public funds. F, a person who is a chronic alcoholic. G, a person who is a drug addict or is reasonably suspected of engaging in drug trafficking. Then you have the other classes where you have the issue of subversive activity and terrorism. Now, according to the law, these criteria will apply to somebody who wants to enter the country at the airport, or somebody who is in the country and wants to have a permit. How in practice this is going to be implemented, Mr. Deputy Speaker? Now, I continue. Then we come to the section K, where a person who, from information or advice which in the opinion of the minister, that is the Prime Minister, is reliable information or advice and is likely to be undesirable habitant. How do we define reliable information, advice, and we decide on the possibility of that person to stay in Mauritius or to be evicted from Mauritius? I have been in the Prime Minister's office, Mr. Deputy Speaker, and I can tell you that you have many anonymous letters from aggrieved citizens or non-citizens writing all sorts of stories just because they have a personal problem with a migrant, a citizen or a non-citizen. When will the Prime Minister have time to check whether the information or the advice and the information has to be reliable, which proves that the person is undesirable? But these words in law, what do they mean? How do we apply them? And when we say then that we can have absolute discretion, Mr. Speaker, sir, then you have a person or a class of person where again we have this, in the opinion of the Prime Minister, is reliable information. Where is the due diligence done? Or advice again is likely to be prejudicial to the interests of defense, public safety, public order, public morality or public health. This is a blanket. And when you have a blanket together with absolute discretion, you know that you can do whatever you like, Mr. Deputy Speaker, sir. And again, in the end, section N, any other person who from information, again, reliable source, advice, has been conducting himself or in a manner prejudicial to the peace, defense, public safety, public order, public morality, public health, security, or good governance of Mauritius. But this is too broad an umbrella. And I think that that's where I said we have to remove this issue of absolute discretion. Then again, you have all the criteria, they cannot enter, they cannot remain. But notwithstanding subsection 1, that is all the criteria, the minister may, on such conditions as he may impose, authorize in writing under his hand and under the hand of a person designated by him, a non-citizen to be admitted in Mauritius or to remain in Mauritius. At the end of the day, c'est la discrétion du roi to stay or not to stay, to enter or not to enter. That's why I'm saying, Mr. Deputy Speaker, sir, that this is too much of powers. Now you have the eligibility for a residence permit, and again here we have the integrated resort scheme, real estate scheme, investment home scheme, property development scheme, and again we come to the sum of $375,000 US. But again here, later I will say, the due diligence exercise in many cases have been flawed. And we know, I'm not going to talk about the individual cases which have been mentioned on both sides of the House. But the due diligence exercise by the EDB in many cases has been flawed. Source of funds. So what I'm saying, in fact, is that strict laws and absolute discretion is not the solution. I will come back now to this residence permit, where you are given the different categories, and again it relates to $375,000. And then, in the end, again, all these criteria do not matter. If he's a student in Mauritius, he's in actual attendance and in college. But the Prime Minister can allow him to have a residence permit if he is such person who belongs to such class of persons as the Prime Minister thinks fit and proper. How do we define the fit and proper? Who is fit and who is proper to stay and not to stay, Mr. Speaker, sir? Again, we come to this issue of discretion, Mr. Deputy Speaker, sir. And we come again, where an application is made under Subsection 2, the non-citizen meets the requirements of this Act. The Director General of Immigration may, with the approval of the Prime Minister, issue the non-citizen with a residence permit. Or, if he does not meet the requirements of the Act, then the Director General of Immigration shall reject the application. However, notwithstanding this section, the Prime Minister may issue a residence permit to a non-citizen, where the non-citizen is, in the opinion of the Minister, a fit and proper person to become a resident. So we have a set of criteria, but at the end of the day, we do not apply the set of criteria, because then the Prime Minister has the absolute discretion to say yes or to say no. Mr. Deputy Speaker, let me now come to the permanent residence scheme, where you have the holder of a residence permit as a retiree or an occupation permit. He can apply for the permanent residence scheme. And the permanent residence scheme is for a period of 20 years. I have only 2 minutes? Oh, I'm sorry, Mr. Deputy Speaker. Well, then I will, before concluding, I have to conclude, is the issue of occupation permit. This silent agreement system, where the Director of the Immigration shall, on receipt of an application, immediately issue an acknowledgement of receipt, and within 5 working days, if nothing is done with the silent agreement, that person will be given an occupation permit. And we know the flows. We know what has happened in the past. So what I'm proposing, Mr. Speaker, sir, Mr. Deputy Speaker, is that the issue of strict laws, absolute discretion to the Prime Minister is not the solution. We have to reinforce our institutions, but that is another big problem. For example, the EDB, for example, the FIU. We should have the due diligence. We should have the image of a country, Mr. Deputy Speaker, sir. We cannot have the image of a country where the Prime Minister decides who is going to come in and who is going to stay and who is going to be evicted. And the Ministry of Labour has to have a proper due diligence exercise before the tens of thousands of migrant workers are coming to Mauritius. We know how the job contractors work. We know what is happening at the ministry. How did they get the permit? So, Mr. Deputy Speaker, sir, I'm going to end on by saying this. We have to remove the word absolute discretion. The bill tarnishes the image of Mauritius as a land of promise, be it for the investor, be it for the student, be it for the young professional. We want to be a Mauritius which is a welcoming hub. This is our future, and we should have the mechanism to be able to see to it who comes in, who stays, who can make Mauritius a land of promise, and where he can set up a new life, start a new life. But it is not with strict laws and absolute discretion to the Prime Minister that we can do this. Thank you, Mr. Deputy Speaker, sir.
Thank you very much. Mr. Speaker shall resume the chair.
Please be seated. Honourable Tilak.
Thank you, Mr. Speaker, sir. The debates around the immigration bill, surtout les discours venant des bancs de l'opposition, appear to be a bis repetita of speeches made by the opposition in 2019 when the immigration amendment bill was introduced. Of course, save for Honorable Buddha, who was at that time sitting on this side and who supported the philosophy of the immigration amendment bill, and surprisingly today is strongly opposed. Inale too.
You continue.
I think he was aware that I was going to refer to his speech. Mr. Speaker, sir, a lot has been said, and though some members have had reservations as to why the government is coming forward with the new immigration bill, Mr. Speaker, sir, it is clear, as lengthily debated already, that the 1970 Act, as amended, need to be revamped, and there is a need to bring in new provisions to adopt with the new immigration realities. So many countries are tightening their immigration policies. Countries like France, England, Australia, New Zealand, which previously had lenient immigration policies, are today tightening their laws. Mr. Speaker, so our country has historically been a land of settlement, and today we have plenty of foreigners either working or studying in the country. And as the Prime Minister rightly mentioned, as regards marriage of convenience, the problem does not lie in the marriage, but in the intention of the non-citizen whose main aim is to continue to reside in the country, using as cover its residence permit as spouse. Some ill-intentioned persons have gone that far by marrying Mauritian citizens for the sole purpose of obtaining a residence permit to stay in the country. When facing restrictions, these foreigners invite citizens abroad and have recourse to a civil marriage in their country of residence. Hence, it is our duty as a responsible government to put an end to such abuse. And it is positive to highlight that Mauritius today is host to almost 30,000 foreigners, either workers or students. And Mauritius, Mr. Speaker, sir, is a jurisdiction which has all positive parameters to attract foreigners. And therefore, it is even more important for us to ensure that we have the legal means to secure our borders and to secure the population from unscrupulous persons to settle in our country. Mr. Speaker, sir, I wish to come straight to one point which has been criticized a lot by the opposition, the amendment being brought to the Mauritius Citizenship Act, namely Subsection 8, where the minister, in his absolute discretion and without giving any reason, deprive any person of his citizenship of Mauritius if he has reliable information and is satisfied that it is in the interest of defense, public safety, or public order. And here, Mr. Speaker, sir, the same arguments of absolute discretion or arbitrary powers being given to the Prime Minister from the opposition. Firstly, Mr. Speaker, sir, if we go through the provision, this provision does not actually give the Prime Minister any absolute discretion. It does impose certain conditions under which the Prime Minister can activate this provision. That is, he has to have reliable information and he has to be satisfied that it is in the best interest of the defense or public safety or public order. These have to be met before this provision is actually activated, and thereon action is taken for deprivation of any citizenship. And Mr. Speaker, sir, the question is, what if tomorrow the Prime Minister does receive information that someone within our territory is a drug dealer, or is a sex offender, or is a terrorist? And of course, being the Prime Minister, so many information is relayed to him. We rely on intelligence. This is how the country works. And the Prime Minister receives such information that there is someone who has committed sexual assault in his country of origin, he's in our country. What do we do, Mr. Speaker, sir, as a responsible government, as a caring Prime Minister? What does the Prime Minister do? So, the Prime Minister should, as the law presently provide, serve a notice to that person, state the grounds to that person, and until then, the person being free within our territory. And for instance, a sex offender, leaving all our children, leaving my daughter, for instance, pray to that person. I think today, the world we're living in, it is important, if we mean business, if we mean to protect the population, if we want to protect the population, if we want to protect our borders, we need strong provisions in our law to ensure that action is taken when it needs to be taken. If there is intelligence that there are such persons within our territory, it is only right and only legitimate that the Prime Minister activates this provision and kick that person out of the territory. This is how these persons should be treated. Our land, our paradise has been secured, and we live by our culture, a Mauritian culture that has gone from generation to generation. Today, there is globalization. Today, we are opening borders. Today, we have many foreigners within our territory, but that does not mean that we need to tolerate or we need to host people that can be a threat either to national security or to public order. this is very important for all of us to understand. We are not only politicians, we are not only elected members of the parliament, we are also responsible citizens. And we need today to make a distinction, ce discernement entre cette personne to whom we can serve a notice and state the grounds and say, okay, we are depriving you of your citizenship, and that other category of person where he needs to be kicked out, I say it again, Mr. Speaker, sir, out of the territory as soon as we have intelligence, as soon as we have information that the person does not deserve to be in our territory. So, introducing when amending the Mauritius Citizenship Act by introducing this new provision is only legitimate in the present context we are living. And Mr. Speaker, sir, it's nothing new about this section. Allons faire référence to England, to the UK. The British Nationality Act, under the British Nationality Act, the Secretary of State may by order deprive a person of a citizenship status. The Secretary of State may by order deprive him of that status if the Secretary of State is satisfied that deprivation of citizenship is conducive to public good. This type of legislation, this type of provision is already existing in the British Nationality Act. There's nothing new to it. When it comes to public good, when it comes to public order, we need to take the right action. So there is no room to come to this House and to come with lengthy speeches and arguments talking about democracy, talking about abuse or absolute discretion and all. Let me remind everyone that we have an index, which is the Democracy Index 2021. Mauritius is ranked among the 21 countries who are categorized as the full democracy. So we are still on a worldwide scale recognized as a full democracy, though whatever is being stated by the opposition or by people outside this House who have ill intention and political motivation just to see that everything that is being done by the government is not right. Every single thing being done by the government, never right. Everything is being soit politisé, soit des attaques personnelles. We are seeing it every day, Mr. Speaker. So we are seeing on the radio, we are seeing in the press, we are seeing it. Today, on diabolise le gouvernement. On diabolise le gouvernement. Quelqu'un vient à la radio, he comes with a statement, he comes with a piece of paper, he says everything he wants, and we start pointing fingers. We need to know. Je le redis, on doit faire ce discernement entre la responsabilité du gouvernement, the national security of a country, and then la démagogie, Mr. Speaker, sir. It is important. This government, Mr. Speaker, sir, means business. It has a roadmap. It has a program. It has been proceeding step by step along that roadmap, along that program. Of course, come in the middle, COVID, but that also has been tackled seriously, diligently, responsibly. We are still doing the work that has been mandated, that has been thrusted upon us by the people of this country. And we will continue with our work. Aujourd'hui, venir avec des mensonges, venir avec la démagogie, come in the press or the radio and saying whatever you want. Ben, comme le Premier ministre le dit, l'avenir est très proche, va révéler la vérité et va éclairer la population sur tout ce qu'on entend autour de nous aujourd'hui. And at that time, Mr. Speaker, sir, the opposition that is grabbing the leg of that one person that is claiming to be the savior and the hero of this country at that time, when the time will come, they will have to stick their head in holes and hide in shame. And Mr. Speaker, sir, that day will come very, very soon, where we will know who is responsible, who is working in the best interests of the country, and who is protecting national security of this country, and that is none other than the Prime Minister, Pravin Kumar Jagnnath, Mr. Speaker, sir. Mr. Speaker, sir, I think I've said what needed to be said about the point of, allons dire, le point de discorde par rapport à ce projet de loi que, à mon sens, a été l'objet de beaucoup de débats. So, I'm nearly done, Mr. Speaker, sir. The only thing is that today, I reiterate the fact that we need to have a very strong, rigid, and well-framed legislation to allow us not only to control the ins and outs of foreigners within our territory, but also to ensure the security of our population and ensure that people that are admitted to the country are people that will not disturb public order and will not disturb national security. I'm done, Mr. Speaker, sir. Thank you so much.
Prime Minister.
Mr. Speaker, sir, I've been very attentive to the lengthy debate. Now they're all going. Almost bon Dieu. Almost bon Dieu, c'est.
Order.
Non, t'as deux pour faire macarine, toi. Allez, casse-paquet. What a shame. Look at this opposition. They have intervened. Mr. Speaker, sir, they have intervened in the debate, and I'm prepared to reply to them. I thought at least those who have intervened could have remained in this house to listen to my arguments. But look at them. It's empty house on the opposition. C'est une opposition avec le lion, le coq, le requin, moustache, et les corbeaux. But anyway, I can tell you, Mr. Speaker, sir, and I can tell the House, this is no distraction to me. No distraction to me. I'm focused. And I can tell you, Mr. Speaker, sir, that I will assume my responsibility to the hilt. So I have been very attentive to the lengthy debates by both sides of the House on this very important bill, which has in fact consolidated all the changes brought since its enactment in 1970 and has at the same time brought some pertinent amendments to address practical problems encountered throughout its implementation. And it is high time for new legislation to meet the emerging challenges posed and to alleviate the pains endured by many of our citizens by ill-intentioned non-citizens. Allow me to take this opportunity to thank all the honorable members who have intervened and brought their contributions to the immigration bill, which I presented last week. Mr. Speaker, sir, let me start by saying that the members, in fact, members of the government side have replied to almost all issues raised by members of the opposition. However, I would like to shed some further light on some few issues which may, if ever, still be shady. Before I make my comments on the points raised from the opposition, I would like to highlight the main objectives of the bill, which are, amongst others, to consolidate and strengthen the existing Immigration Act, which was enacted more than 50 years back, as well as to address suspected cases
of marriages of convenience, which are on the increasing trend. It is a fact that fast developing countries with growing economies tend to have an influx of foreign nationals seeking permanent settlement thereat by various means. Mauritius has not been spared of this phenomenon. It is unfortunate that some of our citizens have been lured and abused by foreign nationals just for the sake of having permanent residence through the sacred bond of marriage. As the Prime Minister of this country, I cannot remain insensitive to the difficult situations faced by our citizens who become victims of marriage of convenience, and I'm thus duty-bound to take appropriate measures with a view to addressing such problematic issues and preventing unscrupulous non-citizens to lure our fellow citizens for the sole purpose of obtaining the status of resident to enable them to continue to stay in our country. Apart from introducing a 2-year temporary residence permit for non-citizen spouses, consequential amendments are being brought to the Civil Status Act to provide that no marriage between a non-citizen and a Mauritian citizen would be celebrated in Mauritius before the expiry of a period of 30 days instead of the current 10 days, starting on the first day of the publication. This measure would enable relevant authorities to conduct appropriate checks on the non-citizen. Furthermore, other consequential changes are also being brought to the Mauritius Citizenship Act. Henceforth, a non-citizen who is married to a citizen and who intends to be registered as a citizen of Mauritius would be eligible to apply for the registration 4 years after having been issued with a residence permit as spouse. An aggregate period of residence of at least 4 years in Mauritius for both spouses would be considered, that is, the period of temporary residence would be considered when assessing applications for Mauritian citizenship. Mr. Speaker, sir, let me make a few remarks on what I heard from honorable members. First of all, I must say that this bill has been prepared in the best interests of our citizens. The primary motive of my government has always been that of placing people in the forefront of policies which affect them. In fact, my speech during the debates of the second reading of the Immigration Amendment Bill in 2019 bears testimony that I did inform the House that the existing Immigration Act needs a complete review, along with other related legislations such as the Civil Status Act, the Mauritius Citizenship Act, and the Deportation Act. And to that effect, the different legislations were being examined in a holistic manner. Moreover, my government had signified its intention to review the legislation relating to immigration matters in our government program 2020-2024. Mr. Speaker, sir, during the past days, I've closely followed and listened to the comments aired by some people, not only on the radio, social media, and of course in this August Assembly. While it is good that citizens show interest to the amendments being brought through this bill, I am, however, surprised by some frivolous comments tending to the misconception that a Mauritian-born citizen can be deprived of his citizenship. I wish to emphasize that Section 22 of the Constitution of the Republic stipulates that, and I quote, "Every person born in Mauritius after 11th March 1968 shall become a citizen of Mauritius at the date of his birth," unquote. this is subject to either of his parent being a citizen of Mauritius. Mr. Speaker, sir, let me therefore at the outset point out that there is no provision in the Mauritius Citizenship Act or any other legislation to deprive Mauritians born in Mauritius of their Mauritius citizenship. The Act has, since its proclamation, been regulating the stay and grant of Mauritius citizenship to non-citizens. Hence, the new provisions will only affect persons who have acquired their Mauritian citizenship through registration or naturalization. The adverse comments made by some people to influence public opinion are therefore erroneous, ill-intended, and misleading. Mr. Speaker, sir, I am also disappointed by the comments made by Honorable Utim, who has supposedly analyzed the proposals made with, as he says, a loop. He has seen that we are depriving Mauritians of their citizenship. I would advise him to increase the magnifying power of his lens, to read the other parts of the bill where, in fact, we are doing the contrary of what he is saying by repealing unjust provisions under sections 5, 9, and 14 of the Act, which impose that a person should first renounce his citizenship of origin to acquire Mauritian citizenship, while in fact, Mauritius allows citizens to hold more than one nationality. And this would have been the case, Mr. Speaker, sir, incidentally, to Dr. Naveen Ramgoolam. Mr. Speaker, sir, the repeal provision has addressed an anomaly where the risk of a person becoming stateless is more apparent and more likely to happen contrary to international conventions. My government is correcting these unfair provisions. Mr. Speaker, sir, I would also like to reassure the House and the population at large that under Section 11.3b, Section 11.4b, and Section 12.1b of the Mauritius Citizenship Act, the Minister shall not deprive any person of his citizenship of Mauritius where it appears to him that the person would become stateless. These are the assurances and safeguards provided by the law to prevent rendering a person stateless for whatever reason, albeit being a non-citizen. In fact, the proposal to deprive persons of their Mauritian citizenship is targeted against those foreigners who have acquired Mauritius citizenship through fake marriages and those dubious persons, that is, criminals and fugitives such as Peter Jurisek, whom the Slovak authorities took care of him in April 2022. The same Peter Jurisek was planning to marry a Mauritian citizen to be able to live permanently in Mauritius. Just imagine what would have happened if he had already married the Mauritian and had already acquired the Mauritian citizenship. We would not have been able to hand him to the Slovak authorities. This is the type of persons we are targeting, and whom the Honorable Utim fiercely defended in this August Assembly itself. That shows the true face, the true face of the opposition. Mr. Speaker, sir, by amending Section 11 of the Mauritius Citizenship Act, it is specifically these types of situations that we intend to prevent. Mr. Speaker, sir, Honorable Utim evoked international conventions and gave the impression that we were not aligned to Article 15.1 of the Universal Declaration of Human Rights, which stipulates that, I quote, everyone has the right to a nationality, unquote, and Article 15.2 where, I quote, "No one shall be arbitrarily deprived of his nationality, nor denied the right to change his nationality," unquote. These are fully enshrined in our domestic law. In fact, Mr. Speaker, sir, all persons born from Mauritian parents on our soil acquire Mauritian nationality de facto. There is presently no reported, nor any recorded case of stateless person in Mauritius, either by birth or by the application of the law. With regard to the 1954 UN Convention relating to the status of stateless persons, I find it surprising that it is only now that Honorable Utim is finding that we have not ratified the convention after 68 years. But as we say, it's never too late. Mr. Speaker, sir, it is true that the African Union Convention governing the specific aspect of refugees problems in Africa, and which Mauritius signed as far back as 1969, has still not been ratified. This because we have reservations on some articles regarding refugees and asylum seekers, where there may be serious legal and immigration implications for the country. Mauritius has in the past adhered to various other instruments on nationality. However, the Republic of Mauritius, being a small island developing state and a densely populated country with limited resources, we cannot ratify all international and regional conventions regarding nationality and statelessness for obvious reasons. Still, our laws contain many provisions on nationality derived from international instruments, and I must say some are even more favorable than actual provisions prevailing in many countries. Mr. Speaker, sir, the reputation of Mauritius cannot be disputed as a fair and democratic country, abiding to human rights on the African continent and at international level. In fact, in the year 2021, Mauritius received an A grade following an assessment made by the Office of the United Nations High Commissioner for Human Rights Committee for the implementation of recommendations of the legal obligation of states parties that have ratified the International Covenant on Civil and Political Rights linked to the treatment of asylum seekers, refugees, and stateless persons. What more testimony can we expect? Mr. Speaker, sir, some people have been making much noise these days about the discretionary powers of the minister. This is not a new provision and neither a new concept. In many laws, such discretionary powers are prevalent since long in Mauritius, as well as in other jurisdictions. Mr. Speaker, sir, nationality is one of the most important sovereign components of a country and is considered as a human right. However, some people are increasingly having resort to all sorts of maneuvers, either through marriages of convenience or under other schemes, to circumvent the law for the sole purpose to reside in Mauritius and acquire Mauritian nationality. It is therefore my responsibility as Prime Minister to ensure that this sovereign aspect is not used by ill-intended and unscrupulous persons or even criminals to hide in Mauritius and to commit other crimes under the cover as being a Mauritian national. Mr. Speaker, sir, Honorable Utim had in his speech went on with this argument on absolute discretion. I heard another member today talking about absolute discretion. He even said that we should remove it. Well, if he was serious, he should have been in Parliament to move for an amendment to remove it. Where is he? But they say that we should remove this absolute discretion by mentioning that the Immigration Amendment Bill in 2019 was aimed towards giving the Prime Minister an absolute power to deprive a resident of his status of resident, and referred to Section 6(1) of the Act. Let me inform the House that the Immigration Amendment Bill 2019 did at no time amend Section 6(1). In fact, the Honourable Member should not mislead the House. Section 6(1) of the Act existed since long, even at the time when former Prime Ministers were in power. The existing and prime provision, and the same provision at Section 6(1) has been included in this bill at Section 18(2). In fact, I must say, Mr. Speaker, sir, if the Honourable Member had taken the time to study the new bill with his loop and the existing Act, he would have certainly noted that several provisions of the existing Immigration Act has been kept as it is in the new bill. The bill has only consolidated and realigned all the provisions and amendments to make the legislation simpler. The same argument applies to the criteria for fit and proper person. Now again, Mr. Speaker, sir, I think Honourable Utim has very less argument on this present bill. That is why time and again he focused on amendments made to the Immigration Act in 2019. He mentioned that in 2019, the Prime Minister was given power to declare as prohibited immigrant any foreigner, which in his opinion was likely to be prejudicial to the interests of defence, public safety, public order, public morality, or public health. I don't want to repeat the arguments of 2019, but let me inform the House, because it is good to know, that the amendments were made taking into account best international practices concerning immigration legislation. I informed the House earlier that immigration issues are not the concern of only our country, but of several countries, including developed countries. And that is why we have adopted their respective legislation to new challenges that are posed by growing cross-border mobility of persons. In fact, during the debates on the Amendment Bill of 2019, I did take examples of legislation in some other countries. For instance, in Singapore, and let me mention again, where Section 8 defined prohibited immigrants as, and I quote, any person who, in consequence of information received from any source or from any government through official or diplomatic channels, is considered by the minister to be an undesirable immigrant, unquote. Approximately similar provision. I also cited the example of New Zealand, where according to their legislation, and I quote, certain other persons not eligible for visa and entry permission include where the minister has reason to believe is or is likely to be threat or risk to security, or is likely to be threat or risk to public order, or is likely to be threat or risk to the public interest, unquote. To add on, I also took the example of Norway, where, and I quote, a foreign national may be rejected when it is necessary out of consideration for national security, public health, public order, or international relations of Norway or another Schengen country, unquote. Mr. Speaker, sir, you will tell me Singapore, Norway, New Zealand, these countries. Well, let me say we are proud to have in fact, looked at their legislation and to have also been inspired by their legislation in order to enact same provisions here. That is why I say we have aligned our legislation with international best practices to address the challenges faced by growing movement of persons, and I will not agree at all with the honorable member that we are going backwards. Are these countries going backwards? Mr. Speaker, sir, let me here inform the House that such provisions to deem foreigners as prohibited immigrants are seldom used, only in exceptional situations. And I hope one of these days, if the opposition will not dare to put that question, one member from the government would put a question with regard to people who have, where we have applied this provision in order to prohibit, to declare some people as prohibited immigrants. So that we then will know exactly in what cases, what kind of cases the Prime Minister has used this discretion. Since 2019, as I say, only a few foreigners have been declared as prohibited immigrants on the basis of information received. Let me cite a few examples. A Mauritian citizen informed the Passport and Immigration Office that she was rewarded a sum of 100,000 rupees for her marriage and that her spouse was not living with her. They got married in Bangladesh. The Mauritian spouse was 57 years and the foreigner 34 years. In a statement, the foreigner acknowledged having given the Mauritian citizen a sum of money for the marriage to be able to stay in the country. On the basis of the facts and averments of the citizen and non-citizen, the latter was deprived of his status of resident. In another case, two ex-Mauritian female spouses of a foreigner complained that their spouse had married them for the sole purpose of staying in the country. The foreigner sexually abused them, including forcing them to practice. I don't want to give details. The foreigner was also subject to indecent behavior towards his former in-laws. Furthermore, the ex-spouses were also victims of domestic violence. It was also reported that the foreigner sexually abused a minor of 13 years, and as a consequence of this act, the minor delivered a baby. The said foreigner then applied to get civilly married to a third Mauritian citizen. Do you think that we should have allowed such a non-citizen to abuse yet another Mauritian female citizen, Mr. Speaker, sir? Well, these are the people they are defending. Now, recently, whilst perusing documents submitted by a foreigner in relation to proposed civil marriage to a citizen, it was observed that the foreigner was convicted on not less than 15 occasions, including for offenses related to consumption and supply of drugs. When this office raised an objection to the intended marriage, the foreigner did not turn up at the hearing. It was reported that he had left the country. In view of the serious nature of the offenses and occurrences, as well as the risk that the foreigner would contract a civil marriage with a citizen abroad, he was declared a prohibited immigrant. And needless to remind the House of the case of Mr. Yurisek, where on the basis of reliable information to the fact that he was wanted in his country, amongst others, for establishing, masterminding, and supporting a criminal group, as well as illicit manufacture, possession of trafficking in narcotics and psychotropic substances, poisons or precursors. He was therefore deprived of his status of resident. For recall, he has already been sentenced to 22 years of imprisonment. And this is the kind of person that Honorable Utim has been vehemently defending in this National Assembly. Mr. Speaker, sir, in his speech, the Honourable Member mentioned that according to Section 20, 4 of the bill, the Prime Minister is given the power in his absolute discretion to cancel the visa of a non-citizen. I note that the Honourable Member has cited only part of the section. In fact, the section reads as follows, and I quote, "Where in relation to the holder of a visa, the Minister, A, is satisfied that it is in the public interest to do so, or B, is of the opinion that the person is a prohibited immigrant, he may in his absolute discretion cancel the visa and that person shall be a prohibited immigrant." Unquote. Mr. Speaker, sir, in the event a holder of visa is declared a prohibited immigrant, on the basis of a valid reason, or where the Minister is satisfied that it is in the public interest to do so, should there not be a provision to cancel his visa? Should the person be allowed to continue to stay in the country? As I say, as a caring government, I am duty-bound to act and take decisions. I ask myself the question as to whether Honourable Member expects foreigners who default the legal provisions of countries such as the United Kingdom or the United States of America or Australia to receive royal treatment. Look at what in other countries, what will happen. Can any foreigner allow himself to do anything he wants in these countries? In fact, the immigration laws are so strict in those countries that you can expect the foreigner to be deported right away without any right of appeal. Regarding the issue of wide powers of the Director General of Immigration raised by the Honourable Member, I wish to inform the House that presently immigration officers, being police officers, they already possess powers under the Police Act as mentioned in Section 25 of the bill. With this new bill, additional powers are being bestowed upon officers, that is, to summon and to hear witnesses. This is a common practice in many other countries, for example, like in South Africa, in the United Kingdom. And in fact, to prove that a marriage is a marriage of convenience, the immigration officer needs to have evidence, be it primary or documentary. Mr. Speaker, sir, as regards the appointment of the Director General, I again wish to point out that the Honourable Member should have done his homework well. With regard to the appointment, the principle has remained the same. The only difference is in the definition. According to the Immigration Act 1970, the immigration officer means a public officer designated as such by the Minister to carry out the provisions of this Act. And in the Immigration Bill, the Director General of Immigration has the same meaning. And it has been the case. The appointed officer is a public officer. It is a police officer in this case, sorry. And it will continue to be the case in the future, unless, of course, we have another minister who decides otherwise. I also wish to emphasize that the concept of Director General exists in several countries, such as the United Kingdom and South Africa, and we are again aligning ourselves with international practices. Mr. Speaker, sir, I think I have canvassed and clarified in detail the need for coming up with this bill. I will thus end by thanking all the intervening honourable members for their contribution to the bill. I will also like to thank the staff of my office and the Attorney General's office for putting timeless efforts in finalising this bill. This initiative will yet mark another achievement of my government in terms of honouring our engagement taken in our government programme 2020-2024. With these words, I commend the bill to the House.
The motion seconded. The question is that the Immigration Bill number 12 of 2022 be read a second time. Those in favour say aye, those against say no. The ayes have it.
Public Bills Committee stage. Clause 1, short title. Clause 2, interpretation. Clause 3, delegation of powers. Clause 4, entitlement to admission to or to remain in Mauritius. Clause 5, restriction on admission to or to remain in Mauritius. Clause 6, status of resident. Clause 7, eligibility for temporary residence permit. Clause 8, eligibility for residence permit. Clause 9, residence permit for non-citizen spouse. Clause 10, residence permit for retired non-citizen. Clause 11, eligibility for permanent residence permit. Clause 12, eligibility for occupation permit. Clause 13, eligibility for short-term occupation permit. Clause 14, eligibility for family occupation permit.
The question is that clauses 1 to 14 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 15, deposit or bank guarantee. Clause 16, return undertaking. Clause 17, application for renewal of permit. Clause 18, deprivation of status of resident. Clause 19, ceasing to hold status of resident. Clause 20, visa. Clause 21, non-citizen minors admitted to Mauritius. Clause 22, examination by immigration officer. Clause 23, powers to refuse admission to Mauritius. Clause 24, inspection. Clause 25, powers of arrest, detention, and investigation. Clause 26, removal of passengers. Clause 27, unauthorized disembarkation. Clause 26, clearance of vessels. Clause 29, security in respect of crew member. Clause 30, return passage ticket. Clause 31, identification number of residents. Clause 32, register of non-citizens. Clause 33, sharing of information. Clause 34, period of residence. Clause 35, lawful custody. Clause 38, Clause 636, offences. Clause 37, regulations. Clause 38, repeal.
The question is that clauses 15 to 38 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 39, consequential amendments.
Move for an amendment to clause 39 as per the amendment circulated.
The question is that clause 39 be amended as per amendment circulated. Those in favor say aye, those against say no. The ayes have it. The question is that clause 39 as amended stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 40, saving and transitional provisions.
The question is that clause 40 stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
The schedule.
The question is that the schedule stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favor say aye, those against say no. The ayes have it. The final question, the question is that I do report to the House that the Immigration Bill number 12 of 2022 has passed a committee stage with amendment. Those in favor say aye, those against say no. The ayes have it. Please be seated. Honourable members, I have to report to the House that the Immigration Bill number 12 of 2022 has passed the committee stage with amendment.
Third reading.
That the Immigration Bill number 12 of 2022 be read a third time and passed.
Seconded. The question is that the Immigration Bill number 12 of 2022 be read the third time and passed. Those in favour say aye, those against say no. The ayes have it.
Speaker, sir, I move adjournment of the House to Thursday, 28th of July at 1500 hours.
The question is that the House be adjourned to Thursday, 28th July 2022 at 3 p.m. Those in favour say aye, those against say no. The ayes have it. The House stands adjourned. Specific matter, adjournment, none. Thank you very much.